A really common question for barristers, apart from, oh, I've bought a jumper, I don't like it, can I take it back, is how can you defend somebody when you know they're guilty? And that's two questions. There's the sort of moral aspect to it, but then there's the technical, and I think the technical is more interesting, so I'll get onto that in a moment. But firstly, with the moral thing, realistically, it's not our job to decide, guilt or innocence. All we do is we put forward the best case that we can on behalf of our clients. Also, you speak to most criminal barristers who've been around the block a bit. They've all got at least one story of a client that seemed absolutely bang to rights. The evidence was overwhelming, and it turned out they were demonstrably innocent in the end. So that's something to bear in mind. But what about if somebody, how do you actually go about defending them sort of on a technical basis? Well, the first thing is, what do we mean by know they are guilty? Realistically, that is if they tell us they are. If they say to us, yeah, I did it. The mere fact the evidence is overwhelming, the mere fact that, even if they've admitted it in interview, because, there may be challenges to the admissibility of the interview, it's only if they instruct us and say, yes, I am guilty, that comes into play. So can we defend them? Well, yes, we can, because, of course, it's for the Crown to prove their case. However, there are restrictions. And generally speaking, it's that we can test the evidence, but we can't put forward a positive case of, didn't do it. And it's probably easier to explain by example. So say, for instance, it's an ID case. And, there's an eyewitness who said they saw the perpetrator and they've identified, our chap. We're allowed to go in there and say, okay, what were the lighting conditions like? It's dark, wasn't it? You were quite a long way away. A bus drove in front of you. You didn't really get a clear view. Were you wearing your glasses that night? What we can do is we can suggest that the ID is unreliable. So we can even go as far as, so you can't be sure who actually you saw, can you? But what we can't do is cross the line and say, because that wasn't my client. Yeah, I put it to you, which nobody actually ever says in real life, but I put it to you, that wasn't my client. Now, if they've gone not guilty and not, admitted anything to you, that's a question you may put, because there's nothing better than somebody saying, well, yeah, I'm not sure, because obviously the test for the jury is so that you can be sure. And if you can say, well, the star witness isn't sure, then, that's pretty much a slam dunk, get you out of jail free card. But yeah, that's pretty much it. So, yeah, we can test the evidence. We can, suggest it's unreliable. We can suggest somebody's got a motive for putting forward false testimony. But what we can't actually do is cross that line and suggest that actually the evidence is false. All we can say is it's unreliable and therefore it's not safe to convict. So there you go. As always, if you found that interesting, please consider clicking the like button, subscribing and sharing.